Hello, everyone, and welcome to today's edition of Nation Watch. I'm your host, Mervyn Williams. It's 23rd March 2025. It's Sunday. It's bingo day here at Congress Place, Sophia. So we invite you to come down and be prepared to take home millions when you leave us this evening. Welcome down to Congress Place. It's bingo day here at Congress Place. We will be discussing a very important topic here in this election year 2025. But before we do, there are some urgent matters which I wish to bring to the nation's attention and some questions I'd like to ask the foreign ministry. So if you know Robert Prasad or what's the gentleman's name, Mr. What's the name of the foreign affairs minister? I don't even remember. These people are so insignificant. But if you know the foreign minister, tag him. I'm told his name is Hugh Todd. My guest today is Dexter Todd. So I didn't want to call Hugh Todd's name and upset my guest. But if you know these people, ladies and gentlemen, tag them. I have some questions for the Ministry of Foreign Affairs. Is there a transnational corrupt deal going on along the border with Brazil? Is there? Robert Prasad, Foreign Secretary, Ministry of Foreign Affairs, traveled to Latam, I think it was on Tuesday morning, en route to the northern state of Roraima in Brazil. Robert Prasad and the Ministry of Foreign Affairs need to tell the people of this country whether that was an official government visit or if it was a private business visit. We know that Robert Prasad was accompanied by a local businessman. A local businessman accompanied Mr. Robert Prasad, who returned to Guyana the next day, Wednesday. Mr. Prasad, was that a private visit or was it a visit of an official nature? Here's why I'm asking the question, ladies and gentlemen. Trucks coming to Guyana from Brazil bringing grain, corn, soy, and so on, often took back cargo from Guyana and hired to Guyanese business people in Latam. Caused a problem. Guyanese business people in Latam complained to the Ministry of Foreign Affairs. That ministry reportedly intervened and caused those trucks to cease their activity carrying freight back to Latam so that Guyanese truckers could benefit from that kind of operation. It caused some problems because it brought about the need for some certification and issuance of import permits, which led to another problem. We know that beef was being imported into Guyana. We said that here on Nation Watch. The party said it on its during its press conferences. The only trouble now is that our investigations have revealed that there's only a solitary facility in the state of Roraima that is legally authorized to slaughter and process meats, beef particularly. Mr. Prasad's visit to Brazil on Tuesday, which ended on Wednesday morning, strangely coincided with some action in Brazil. Was it a coincidence? We're going to show you some images here where the police, the state police in Brazil, visited a particular location and reportedly found illegal slaughter of animals. And the information we have is that the beef was destined for Guyana. The beef was destined for Guyana. We understand, Mr. Robert Prasad and Mr. Hugh Todd, that operatives from your ministry, this is our information, Operatives from your ministry are allegedly involved in some way or the other in facilitating what is happening in terms of illegally slaughtered beef coming to Guyana. You need to come clean and tell us what your visit was about and what you discovered. You see, sometime last year, and the Ministry of Home Affairs may be interested, and the Guyana Revenue Authority may also be interested in this. In the municipality of Bumfin last year, an illegal activity was unearthed, an illegal printing activity. And we have unconfirmed reports that Guyana documents, official documents issued by agencies in Guyana were being forged across there, including birth certificates. This didn't make the news in Guyana, but the GRA may be interested because their Asikuda system, as I understand it, allows only for scanned documents to be electronically entered into their system when it comes to imports and export. So they have not had the opportunity to check the authenticity of the certificates issued by the relevant authorities in Brazil for beef coming to Guyana. I urge the GRA to get to those importers and ask them for the original certificates issued by the agencies in Brazil for the beef exported to Guyana. You might be alarmed. It appears as though not all is well in the import of beef to Guyana. And it's interesting that Mr. Prasad's visit and exit from Brazil coincides with the discovery of illegally slaughtered beef. We'll show you those images again, very unsanitary conditions. And if it was an official visit by Mr. Prasad, why did he spend only one night in Brazil? Why? Speak to us on this issue. This is a kind of unsanitary condition that the state police in Brazil discovered, in which beef is slaughtered destined for Guyana. And we have had what the Ministry of Health has been denying, but it's finally come around to accepting and acknowledging that there is an outbreak of hand, foot, and mouth disease in Guyana. The question for the Minister of Health, therefore, is there a connection? And we have some images of patients in that regard. Is there a connection with hand, foot, and mouth disease outbreak in Guyana and illegal beef coming from Brazil, which was slaughtered and kept in unsanitary condition? So, ladies and gentlemen, if you have connections with the Ministry of Health, the Ministry of Foreign Affairs, the Guyana Revenue Authority, and the police division in Letem, tag them. Let them look at this program and evaluate the information just provided. And you know what's interesting? What is interesting is that there's some political ambitions being exercised here. And I'll tell you, Mr. Robert Prasad and Mr. Todd, and even you, Mr. Jagdeo, that one of your operatives is after the job of the regional chairman of Region 9, Mr. Brian Alicock. And he's getting closer and closer to you to get cover so that he can do the nonsense that he's doing in the hope that you'll cover him. Cut him loose. Cut him loose. He's bad news. We move on, and we'll take a quick look at what happened recently. I alert Guyanese that my information is that this did not happen in Guyana's waters. But the Ministry of Home Affairs and the Guyana Defense Force needs to speak to us as a nation. There was this naval vessel that was videoed from Guyana's shore. My understanding is that this is likely to be a vessel that is returning to Venezuela along the Amacura River from its base, from a military base at a place named Wausa. The Amacura River separates Guyana from Venezuela, as I understand it. And so this river, if it is in fact the Amacura River, is the border between the two countries. But here are the official questions I wish to pose to the Ministry of Home Affairs, the Office of the President, and the Guyana Defense Force. Have you examined this video? Are you satisfied that you know the location of this vessel in this video? Are you comfortable that it is not in violation of Guyana's territorial space? Are these two boats here and a barefoot soldier Guyana's response to that military vessel from Venezuela, flying the Venezuelan flag right alongside Guyana's territory? A 15 horsepower outboard motor and a 25 horsepower outboard motor sitting on two little tinning boats, as we would say in Guyana, with a barefoot soldier. Is that Guyana's defense to the kind of vessel that is going there that allegedly collected a boat belonging to a Guyanese citizen and taking it away? Where is the emphasis on territorial defense in this country? Where is the interaction of His Excellency the President with the citizens of this country to bring us up to date with what's happening on our frontier with a hostile neighbor, Venezuela? These are our vessels, and the one in the big river there is the Venezuelan vessel. Citizens, this is being brought to your attention as a public service announcement. This is not attacking anybody. This is the reality. But I assure you that my information, because I checked this, I spoke with people, and my information is that the vessel is not in Guyana's waters. Where those two little tinning boats are, that is Guyana, I am told. And the other side of the river is Venezuela. This is what I've been told. The GDF needs to come clean and tell the citizens if there is a risk and whether or not this vessel is in Guyana's territorial waters. I go to my guest now, and I'd like to introduce to you, but before I do, may I humbly apologize to Dr. Dexter Todd for taking up so much of his time to bring in those two public service announcements. Ladies and gentlemen, Mr. Dexter Todd, Dr. Dexter Todd, attorney at law, is my guest today. Dr. Todd, I'd like to welcome you to Nation Watch and thank you very much for joining me here. I know that it is night where you are.
Yes.
And I thank you very much for making the sacrifice to speak with us today on Nation Watch. Thank you for joining us.
Thank you so much for having me, and good afternoon to all your viewers.
All right. Now, Dr. Todd is representing the applicant in a matter in the court, the applicant being Carol Smith Joseph, who is the chief scrutineer of the People's National Congress Reform. Dr. Todd, on behalf of Carol Smith Joseph and the PNCR, is asking the court, or has asked the court, to interpret a particular amendment, which was recently made, I think recent as 2022, regarding residency. But before we get there, I want to make this announcement. Every Guyanese is interested in this election because at least 70% of the Guyanese voters want the PPP gone. Now, in this particular case, ladies and gentlemen, I've been advised that all written submissions, oral arguments, and everything have been completed. That process has been closed, and the Honorable Chief Justice has named Friday, 28 March 2025, as the day on which she will hand down her ruling. That means that there's no room in between the time she made that announcement, the Honorable Chief Justice, and the time she will make her ruling. There's no room there for any attorney to go to the court with anything. But I've just been advised by Dr. Todd that the Attorney General of Guyana on Friday filed additional pleadings in this matter. And I'm further advised that this is unprecedented. Dr. Todd, please let's start on this point. Walk us through, talk to us about this new development in the absence of leave of the court.
Thank you so much. Now, submissions were closed, I think, very early in March. And the 17th of March was set for what the court calls amplification, an opportunity for lawyers to basically amplify your written submissions, which were made prior. Now, on the 17th, we had that amplification. And as the applicant, we basically focused more on the submissions of GCOM, because we thought that the submissions, in terms of the substance of the submissions of the Honorable Attorney General, did not adequately or properly, or was it even reasoned enough to represent a defense to the application which was filed. So the Honorable Attorney General basically was asking the court to dismiss the application on a procedural point. And that procedural point was saying the civil procedure rules did not make provision for an applicant to come to the court for statutory interpretation. And we, of course, that would have been, of course, going against all precedent, that even if there were some form of technical error when the 2016 civil procedure rules came into existence, the all high court rules did make provision for there to be statutory interpretation. I don't believe any court will take a comfortable position that a litigant must be shut out of the court because procedurally there was no way in which they can come. That would be outside of the precedents established by the courts around the world. So that was not a strong point. Now, when you went down to the other elements of the submission, it did not really address the issues which arose in the application. So it is my view that the Attorney General was not comfortable in the position to represent a sound legal point. Because you see, this is an issue where we're asking the court to give an interpretation. And that interpretation can, of course, be instructive to GCOM, or of course it can be instructive to the instructive for the legislators, so that they may know that there may be other steps to be taken. Now, what we have, as you rightly said, the 2022's amendment remove the word residency or residence, and it was replaced by a term, and that term is address claim. Now, this amendment did not provide any form of interpretation. You know, like when you have a new legislation,
Their
there is
definitions.
an interpretation part, so that one may never get confused with how a word is used in its context. But this was not the case. Now, how GCOM, and I'm just saying, if I'm permitted, how did the applicant get here? Now, GCOM's understanding, and this is based on a practical operation in the field, what the applicant was seeing as a chief scrutineer is that GCOM officials were just concerned with establishing that an address exists and that there was no connection of the registrant to the address. They were not concerned about that because that was their interpretation of what address claim means. Now, the applicant formed the opinion that even though the term address claimed is used, the interpretation, which is very reasoned, is that it is not an address of record, but the term must be interpreted to mean that it means that the subject, which is the registrant, must be must be a place in which the subject can be contacted, so that in essence the connectivity must always remain. And so we have the applicant as of course voiced certain reports which suggest that in the registration process of new registrant, you had in parts of Berbice, you had 2 busloads of persons coming to be registered, but they themselves could not say or give direction to where their address was. So someone is telling them, give an address, and they just give an address, and that's it. And so the application is before the court to give an interpretation. Is residency verification, was it totally removed? And even with the words being changed from residence to address claim, is there still a requirement for connection between the registrant and the address? Our submissions, of course, went down the line of saying that it's still, in general, there is still a need for verification because 4 out of the 5 elections, which are, of course, within the power of GCOM to deliver, requires them to ensure that the category or the qualifications of voters would be that they vote in a correct place, or that they're casting their vote because they are so qualified to do so. And
Based on a
so
geographic consideration.
that's a geographic consideration. Now, GCOM's submissions implicitly supported that contention that while there is no residency verification for general elections, the other elections, for example, regional elections, still requires residency verification, in that there is still that element which remains. Now, we have a disagreement in relation to that, because we have submitted to the court that general elections has two components. And one of those components is what is termed as the geographical constituency element or component. And that component requires residency verification. Now, and so GCOM, of course, departed from that submissions and from that position and had said, no, general election does not require residency verification. And so that is also an issue in which the court will address its mind to, I am almost sure. So
Oh,
when the Attorney General, Honorable Attorney General, after the amplification on the 17th of March, the next instruction of the court was that I will give a preliminary ruling or a ruling on the 28th of March. At that point in time, there was no application to the court for there to be an additional submission by the Attorney General. So on Friday, when we learned that in the portal, because you know Guyana has gone now to filing submissions and applications virtually. And so when we learned that in the portal, there is an additional submission filed by this respondent, it caught us all by surprise. And because I would sense why that is so, because immediately after the submission you had the CEO of GCOM coming out publicly and distancing himself from the submission of the lawyer, and you had a bout of confusion being brought in relation to GCOM. So I would just anticipate that what the Attorney General was attempting to do at this stage was to represent a particular position, but the time is gone.
after he drafted the release, which didn't get traction.
Yes, yes. So the court, this is without leave. I am not sure that the court will entertain that additional submission. Of course, we are at the stage of ruling, so we of course did not reply to that.
Dr. Todd, it is alarming that the Attorney General feels the way he does about residency. I mean, when this new electoral system was put in place in 1980, the country was divided into 10 administrative regions, 10 geographic regions. Those were divided into sub-regions, and they were demarcated. They were mapped. The sub-regions were subdivided into districts. Districts were divided into communities. Communities were divided into neighborhoods. Neighborhoods were divided into people's cooperative units. All of these local authority areas were demarcated, were plotted on a map, were numbered in the case of people's cooperative units. And those numbers for the PCUs are equivalent, by the way, to zip codes in the US and so on. Why would a government take time to statutorily provide for boundaries within a country if residency within these boundaries did not mean something to the electoral process, which it was now defining? Now, we know that local government elections are, I think, statutorily due every 3 years. So those are held by themselves. The Regional Democratic Council, which I understand to be a local democratic organ, has a statutory life equivalent to the life of the parliament, 5 years, a maximum of, or not exceeding 5 years and 4 months, as I understand it. And so it appears as though, for convenience, the two were merged into a single process. But should not that process take into account the differences of the three elections? Because there is regional election, there is national geographic constituency election, and there is national top-up MPs election going on all at the same time. Is it too much of a load for one exercise? Is that what is causing the problem here?
Well, I see what one of the recommendation was. Or, well, not really a recommendation. One of the consideration, I must say, which was made by Council for GCOM, was, in all intents and purposes, regional and general elections are two separate elections. And I don't think there is anyone which can rightfully go against that understanding, because the laws and there are two different legal systems which allows that election to take place. Now, there must have been a particular reason why the two were accepted in Guyana historically on the same day, and were just demarked, were just separated by perforated line, so to speak, right? There must have been more than just saying the elections can take place on the same day. We believe that there has always been commonalities in terms of the qualifications, because it flowed out of one list. Now, one of the problems that GCOM legally represented in court is that with the amendment of saying that the general election does not require any residency verification, regional elections requires that residency verification. Now, historically, when the electoral roll was produced, it was produced, and so there was only one list in which persons checked their names on polling day and voted. So you have a serious contention now, and I figured that's why a consideration for GCOM, because I don't believe the lawyer was making a recommendation. I believe the lawyer was, of course, going down the line of saying this might now be a consideration of GCOM, that they may, because of the fact that the two elections now are so separated and distinct, that it requires qualifications in two different areas. You may need to have two lists prepared or produced, which is now going to be a new approach that GCOM may have to consider. And that is the reason for that, is because if you are saying no residency verification is required on one, the other one there is, and therefore the same list cannot be used. And so that is a consideration now which faces GCOM, and that, of course, which
it seems to be a fair one. It seems to be a very fair one.
A fair one.
Yeah, Dr. Todd, I believe that GCOM over the years has lost its way in managing elections. Let me tell you why I arrive at that conclusion. Starting in 1980, when this new system, this new electoral system came into being with the regions, ministers of state were appointed to the position of regional ministers, so that regional ministers administered the administrative regions. Now, they came from either the parliamentary list or were co-opted into the parliament and appointed ministers of state. In 1985, the system changed again, where the regional administrations now, having been through a process of regional elections, the regional administrations now elected their regional parliamentary representatives, so that those regional parliamentary representatives came from the RDCs.
Yeah.
And then the system changed again in 1992, where you had the hybrid system that now obtains at national elections. So that from 1992, the RDC started to elect councillors. And councillors of each RDC elected from among their number one to be chairman.
Yes.
So that is how the RDC became what it is today. There was still, however, the requirement for regional representation in the National Assembly of the Parliament.
Yes.
Here is where this hybrid system came into being, where 25 of the parliamentary seats will now come from the 10 administrative regions
Yes.
following national elections, and the other 40 from the national top-up list. I believe that somewhere there, the opportunity may have been missed to put in place the requisite statutory provisions to cater to the two elections at the national level. I believe that's where this problem seemed to be coming from, because the one voting for national election remained. And because the RDC now exclusively handles RDC business and not parliamentary representation election, this element of residency appears to have been overlooked. And it seems to me that the attorney for GCOM was onto something when he made the point that he made. But it appears to me also that GCOM finds a need to hide its deeds and or misdeeds, as the case may be, by shutting out his observation. Where do you see this taking us? I mean, nobody is holding their breath with respect to the ruling of the Chief Justice in this matter.
You see, no one, I mean, if you, and I have taken, I think, quite a global approach to this case. And my training as in both in terrorism and counterterrorism as my specialized area. One of the things that we also embarked on was, of course, looking at the issue of national threats. And that is why I think I made a post that fake residency can also lead to a threat to national security. Because it is what we call in the academic world, we call it a disinformation. Because if you allow persons to deliberately give false information, then you always have to go to examine why that was done. And so in this case, where persons are giving false information, is it for the purpose of manipulating or affecting a particular geographical constituency as to the results at that particular constituency, which is very dangerous. Now, I go back to Articles 9 of the Constitution. And I think sometimes as citizens and as voters, we underestimate the power of the people. Now, this says, and I quote, sovereignty belongs to the people who exercise it through their representatives and the democratic organs established under the Constitution. Now, the power is in the hand of the people. Now, if you are going to give power to somebody to cast a vote, that person must be so qualified to do so. Now, I think we mix this up with the ruling of the Christopher Wren case, which, of course, led, I would say, substantially to the amendment in 2022. Now, many persons, I think, just without deep context, go on to argue that residency was thrown out of the window by the learned Chief Justice in that case. But you have to examine the case and the context in which the case was presented. The case was presented in a way in which there was what we call a returning citizen. And so that person was already registered on the National Register, or the NRR as we know it. Now, not because the person had removed from Guyana and was living overseas. I think at that point in time, there was what we call house-to-house verification. So house-to-house verification at that time, this is before the amendment, was the process in which, of course, the officials will go to various houses to verify whether the person still resides there. And if they didn't find the person, their name would not have appeared on the electoral roll. And so the case of Christopher Wren brought context to that, to say that even if you had migrated, that is not a legal ground on which you can be affected in terms of your votes, meaning that you could not be removed from the NRR. And so the NRR now, we can comfortably articulate that the NRR is a permanent record. So even where a person dies, that person is not removed from the NRR. The person, once a death certificate is produced, and so on, then the NRR, the information, the data in the NRR is therefore updated. So that when you're produced, a dead person ought not to be on the electoral roll, but they still exist in the NRR. All right? So the NRR being a permanent record or data is very crucial, because you have a situation in which even the police force, if they are in search of a person, they can apply for information from GCOM. And so that they can get an address, an accurate address of where to locate the person. So if you run a system where people are allowed to just call any address, could you imagine in a progressive society as ours, one can accept that a person, I am registered at an address on the West Bank. I live alone, I bought the property, no one lives with me. then a person comes who wishes to affect the vote in that particular geographical area. And they decided they are going to use my address. And I am saying when GCOM comes now to verify that there is an existence of that address, they now turn away by saying, "Oh, the address exists," and that's it. We can't accept such an operation because as the applicant has stated, there were live situations in which no one living at the address were of course connected or recognized who the registrant was. So that in itself runs a situation where there can be a national threat because you have the identity not only of name, date of birth, but you have the identity, and when we look at it and from that perspective, which is a sham, is a sham. The person doesn't live at any recognized location in which they can be contacted. And
Sorry, go ahead.
therefore, the contention is that the connection must still remain. If someone gives an address, that address must be a place where they can be contacted. That's simply what the case is saying. Because the information in the NRR remains a vital information for the country. Now, of course, GCOM submitted that some of these issues in relation to wrong address and etc. can be solved by the claims and objections. Period. We of course disagree with that because we're saying that that claims and objections should not be and ought not be for that purpose for which a citizen is coming to articulate to you that the person who is registered at this address and who is allowed to vote in a particular area is not a person who belongs there. Now, of course, GCOM's official at the claims and objection would just refer them to the Christopher Ram case, which they say residency is not a requirement for the general elections. But that's just so that doesn't solve the problem. That basically
Dr.
compounds
Todd,
it.
is that really true that residency is not a requirement for national elections? I mean, I know, for example, that there's a provision that says that Commonwealth citizens resident in Guyana for one calendar year are eligible to vote. It means, therefore, that residency in that regard is a feature of national elections. Secondly, if you are not resident in Guyana at the time of, of an election, you cannot vote. Well, you cannot legally vote in that election. We know what happened in 2020. We know that many such persons had votes cast for them or in their names. But legally, if you're outside of Guyana at the time of a national election, you cannot vote because overseas voting has been abolished. So is it true to say that residency is not a requirement for national elections in that regard?
Well, we will need to examine that very closely. Now, our representation to the court is that residency is still a requirement for general elections, particularly or in the main for geographical constituency. And as I said, GCOM legal representation disagreed, so to speak, on that point because they looked at general elections as one. Now, you are correct. The amendment did not remove the constitutional requirement for Commonwealth citizens who were being registered to allow GCOM to verify their residency or to verify that they have been domiciled in Guyana at a particular location. That still remains. So that argument alone will go to say that GCOM cannot interpret the amendment, especially 6B. They could not interpret that to mean that generally residency is not, a residency verification is not required. Because, as you rightfully said, there is a category of persons in the name of Commonwealth citizens in which their residency will have to be verified. Now we go to the other issue, and the other issue is that the ruling of Ram, and this we can call the progressive nature of how the law, because our laws are developing. Now, from the case of Christopher Ram, that case settled that point in relation to whether an overseas person can return to Guyana and vote. And so I believe, and that case has not been appealed, so that is now the law. A person overseas can come back and vote in the general elections. Now, this is the proposition here. If the person comes back to vote in the general elections, then that person's vote lawfully can only be counted once for the party of their choice, but cannot be counted again for the geographical constituency, because that person would be so disqualified by virtue of the fact that they are not residing in Guyana.
Let's explore that. Let's
Also,
explore that a little bit more. Let's
yes.
explore that a little deeper.
Mhm.
And I want to bring you home to a local experience. I was in Mabaruma in 2020, I believe it was. And there was a person there who had registered at Virginujan in the West Demerara, Essequibo Islands, West Demerara, Region 3,
Mhm.
but had gone to Mabaruma where they had grown up. And they were not allowed an opportunity to transfer, but they had to be home in Mabaruma. That person, notwithstanding appeals to the commission, was not allowed to vote at all because the person did not qualify to vote in the regional elections in Region 1. And the ballot paper is a single ballot paper
Yes.
with two sections.
Mhm.
So that if you give that person that single ballot paper with two voting options, you have no control over whether that person votes for the regional elections as well.
Mhm.
So that what they did is bar the person from voting totally. So because of the residency requirement, there was disenfranchisement.
Mhm.
Now, your case that you just mentioned, the person comes back to the country, is not domiciled here, doesn't have an address in any one of the 10 geographic constituencies, the regions, and can only vote once. But because that one vote comes from a list that is not disaggregated into regional geographic constituency and national top-up constituency, that person still gets to cast a vote where residency is required and the person does not have that qualification satisfied. Talk to us on this matter, Dr. Todd.
It means, and I borrow the words of the Honorable Attorney General. If one vote, just one, it takes to contaminate and allow an entire election to be considered as irregular and therefore can be voided. So, really and truly, and that is why I believe uh, legally GCOM had represented to the court that the issues which now comes to the floor is that you will have to separate the lists because the qualifications of the persons are now separate. And so you cannot, even if a person is living overseas and is no longer resides, let's say a situation where the person has completely migrated for 20, 15 years, they have sold all their properties and so on. The question is, can that person return to Guyana and vote? I'll tell you, following the judgment, which is the settled law now from the Chief Justice, is that the person, yes, because residency did not cannot remove a person's right to vote in the general elections. Now, when it comes to another elections, the regional elections, there is a qualification that the person must be able to satisfy. And that qualification is that the person must be residing in a particular geographical area. And so we are not trying to promulgate that a person must come to to the registering officer and lie. If a person is living overseas, I give your overseas address. I live overseas, because that would not bar you, and I think that's the comfort of the law now. That will not bar you from voting generally, but you will not be able to vote in the regional elections because there is, of course, a different qualifications. So going back to your
Voting for
main
regional MP.
contention, whether GCOM can still continue to have both elections on on the ballot, in which it's just separated by that perforated line. I believe clearly there may very well be a consideration, which has to be that you'll have to tear that off, and so that if the list only carries the person qualified to vote in the general elections, then you can only have one paper, but not you safeguard them voting in the regional. I mean, these are just considerations. These are things that the relevant parties will have to flesh out and interrogate, and to come up with the best solutions in this. I'm just saying what should some of the consideration can very well be from JICA.
Dr. Todd, I want to just ask one other question on this business of the national election here. The component of that election that deals with the regional representative to parliament, those 25 seats, it has been a principled position of the PNCR and its coalition partners that persons who are offered as candidates to fill those positions must reside in the geographic region that they seek election from and to represent. The truth is not the same with the People's Progressive Party. We had Region 3 MPs living in Carmichael Street, and we got Region 7 MPs living on the East Bank and so on from the People's Progressive Party. They don't see that as being important. But we view it as important that the representative of a particular region comes from that region. And I suppose that is rooted in the fact that the election system was designed by the PNC in government. And in that regard, I reference there's this particular order here, I think Order 12 of 1980, which speaks to a lot of these issues. So if the representative must come from the particular region, shouldn't the electors of that representative also come from the same geographic space, as in the case of local democratic organs. If that were to be the eventual position, how would remedies be applied?
I agree with you. I believe in answering that question, you have also preferred a very sound conclusion to that question. In that, the answer I will say yes, because I believe when we really look, and I've done some reading even in relation to the historical development of the democratic organs and this whole question of regional elections. And what I gather from the history is that for all intents and purposes, it has always been the intention for the representatives to come from those areas as well as the votes. I mean, you are electing the person you feel comfortable with in representing you at a higher forum. And so the issue of, I mean, as academics, we would say the issue of being able to accessibility is very important. I'm able to access my leader. I'm able to voice concerns to them. I'm able to have them to see what is happening in the community in my region. And I'm able to have the representation at a higher level. I believe that has always been part of the underpinning why the structure and system was created like that. Should we depart from it? I don't think so. I have not been convinced that we should depart from that. And so I believe the residency qualification remains a pivotal ingredient in relation to how we qualify persons to cast and their votes in various elections.
Yeah, historically, residency is rooted in the electoral process. I refer just now to Order 12 of 1980. It's titled the Local Democratic Organs Act 1980. It is called the Local Democratic Organs Act 1980, and there's an order made from it. This is the order number 12 of 1981. It speaks to residency in so many different ways historically, from the inception of this system of election that we now have. There were regional democratic councils, there were district democratic councils, there were community democratic councils, and there were neighborhood democratic councils, and there was the preservation of the established village within the neighborhoods. So when you look at it, there's an element of residency deeply rooted there, because what are the qualifications of an elector? He or she must be 18 years or older and living in this geographic space. What are the qualifications of the person to be elected? They must be of age and they must be resident within this geographic space. We no longer have district democratic councils. Well, we don't have them.
Yes.
We do not have community democratic councils. What has happened now is that the PPP has removed residency from what they now call CDCs. And those are not community democratic councils. Those are community development councils registered as friendly societies. So they've removed from the electoral system, they've removed from the local democratic organs, and they've established friendly societies and charged them with responsibilities of managing communities.
Yes.
So it is clear to me that the Attorney General has no interest in the preservation of the electoral process as far as the democratic councils are concerned. so that residency means nothing to him. But having said that, Dr. Todd, how confident are you that the interpretation for which you approach the court will be favorable to you and the client involved?
Well, well, as lawyers, we are never one who anticipates where the court will go. Um, what we did present is enough context for the court to consider, and I believe arising out of what GCOM, I mean, who better party to speak about their issues, has highlighted, I believe clearly there is a need for some form of context and direction to be given. It's too crucial of an issue to leave in limbo, so to speak. It requires some form of clear interpretation, um, which will, of course, will give direction, and as I said, will actually give directions to GCOM, so that if that residency requirement was removed, then of course GCOM will have to consider other regulations which would require them to fulfill residency requirement or verification for other elections. And if it's within, not within GCOM, and it's within the legislators to so put certain laws in place, then of course they will have to do so. So I believe either way, in the court, in given context, will be very important. And I'm one who believes that even with the arguments and what has come out of the case so far, it has been a successful case, because I think a lot of things came to the floor, which I think all parties concerned are going to be considering. It's not a case which you are shutting a person out from voting, but it's a case which requires or calls upon the relevant authorities to ensure that the persons are voting in the correct place and that they are so qualified to do so. And I think it's important. It's an important case, which I believe will stand its test as we go forward.
I get the impression from what I'm reading in public disclosures and so on, that the Attorney General appears not to be arguing on the basis of the Constitution or law, but more appealing to the learned Honorable Chief Justice that, look, elections are around the corner, and basically this thing is an hindrance to running the process. My own understanding of what I'm seeing and hearing and reading. And I know that there are times when decisions are taken in a national interest, more than other considerations. Do you get a sense that, and this is again asking you perhaps to do what you don't want to do, to speculate just a little bit, um, if the determination is favorable to you, to your client, do you envisage the need for any, you mentioned legislature just now, do you envisage the need for the legislature to be called to action with respect to remedying the situation were the interpretation to be favorable to your client?
Yes, I think the amendment, and I mean, it's it's unfortunate that one of the comments made was that there were no objections at the time in which this bill was presented by any of the parties in relation to objecting to it. So the amendment was passed That's what was represented, without objections. But I think more as we begin to interrogate that piece of legislation, we recognize that a number of other legislations in relation to elections will need to come into conformity, not only with the Constitution, but also to really give proper effect to that amendment. In that, I believe that while there is a section which says you're removed from residence to address claim, you still have other categories of persons in which the word in which you remove, they still need to be qualified under that word. And so if you're not going to, if you're going to remove the word, then remember, you can't remove and change what is the constitutional requirement. So you will have to again look at bringing that into conformity. And so I would simply say to your question, the legislators, they will have some work to do. I want to also say that it is a misconception in relation to what the action really is. The applicant in this matter is not really focusing on general elections. The thrust of the application is saying, because the NRR now is considered as a permanent record, whatever information goes into the NRR, it must be accurate information. And so therefore, the question which arose is when you're dealing with new registrants, is there a requirement to ensure before you input that information that the person who is now registering is connected to an address? Now, remember, this didn't just flow out of the air. This came as a result of what was happening on the ground and the understanding that the various officials had. And they were saying that address claim means an address of record. The scrutineers, representatives of parties are saying that address claim must be interpreted to mean that the subject must be connected to that address. So we have two interpretations. Which one should we go on? And so if the ruling is that that there is no need to see that the registrant is connected to the address, then that interpretation and action doesn't stop there. It will now go upon GCOM to look at other regulative framework which will assist them to ensure, which will assist them in ensuring that the persons who will vote for other elections outside of a component of the general elections are so qualified, because residency will be, of course, a requirement. So that's where we are.
I have a question for you on the press statement that we just put up on the screen there again. It, it is the view of some people with whom I've communicated that this press statement issued by Vishnu Prasad, Chief Elections Officer, was really an attempt to interfere with the proceedings before the court. Why, for example, did the Chief Elections Officer not stand up in court and dismiss his attorney on the spot? Why did he wait until the next day or several hours later to say, look, this attorney did not represent my instructions, whereas the attorney, for his part, was clearly relying on statutes and constitutional provisions? Is this normal for a state? Well, there's not a state entity, there's a constitutional body. This is a constitutional, independent constitutional body to reject publicly legal counsel. Do you think it was with a view to
It, it
attempt to get the attention of the Chief Justice in some way outside of the court? And is that with or without precedent?
all I wish to say on that point is that one, it was clearly unfortunate, and two, it is unprecedented. I don't believe it will have the effect of trying to influence the Chief Justice in any way. And I speak because of the court's strength and integrity, which has always been demonstrated. I don't think parties, as there's any track record of parties outside have ever been trying to influence in any way. But when I looked at the press statement, it is not a true reflection of the history of this matter. The affidavit signed representing GCOM's defense highlighted that the issues raised by the applicant, they do exist. They have had those problems. And so they didn't distance themselves from the examples that the applicant raised in terms of when persons give an address and you go on at an address, there's an empty lot, there's nobody living there. That they're saying that they represented in their affidavit that the unconnectedness of the registrant to the address has always been a problem. But they're saying, coming down to say, we don't need an interpretation because of the fact that they have not put forward what the interpretation is in relation to this requirement. But they just believe, as I said, from their actions, it is clearly demonstrated that they believe that the term address claim means an address of record. And I think that is where we have the problem. So the submissions, and these submissions were filed long in advance of the 17th. So it is not it's not a situation, and I say it's unfortunate because it brought into question the reputation of a very outstanding, brilliant attorney, because I think what was articulated in court was very impressive. And I think it's unfortunate because one should not do that at all, because I believe clearly the CEO cannot say that the attorney represented certain legal positions which were strange to GCOM or did not have the authorization of GCOM, because the submissions were filed long in advance. And what was amplified in the court were clearly the submissions that were in. So none of us were caught by surprise by any change of the submission. There were no twisting of the submissions. The submissions were, of course, what they are in terms of what was actually filed. So I think it's something that I really do hope that later on there is a need, that CEO sees a need to publicly apologize to counsel, because I believe that was really an attack on his integrity and on his competence, which I believe was clearly unwarranted.
What caught us by surprise was really the fact that this gentleman was actually appointed CEO of the Guyana Elections Commission. That caught us by surprise. But here's this position, Dr. Todd. It is a widely held view that the vague nature of this amendment, the absence of a specific definition of address was calculated. You see, demographic shifts are expensive exercises and exercises that take time. And you may recall that some years ago, there was the tuition housing scheme and the housing scheme at Parfait La Harmonie, where persons from Region 4 were shifted into Region 3, where the PPP felt that they had a solid voter base. And the attempt was to weaken the PNC's voter base in Region 4 by moving out large numbers of PNC supporters and putting them into Region 3, where they'll be absorbed, and the PPP will still have political control of the region. And then when the housing schemes were being built in Eccles, there was an emphasis of shifting people from Region 6 into Eccles. And then there was an attempt to shift the boundary of the city beyond Eccles to Diamond, so that the new housing developments in Diamond and Eccles will fall in the city of Georgetown and give the People's Progressive Party voter advantage to take control of Georgetown, which they've been dying to do from the inception and have failed. There's this widely held view, Dr. Todd, that the vagueness of this amendment of 2022 and the defense of it by the Attorney General has something to do with the manipulation or possible manipulation of addresses to give the People's Progressive Party a geographic voting advantage. Because if somebody lives in one region and registers at an address in another region, and the number of such persons is large enough, the absence of the need to verify those addresses will allow those persons' votes to be cast in the particular geographic space. This thing is riddled with mischief, and the approach to the court for interpretation, in the view of many, is the correct thing to do. And from what you have been saying to us here today, it is evident the Attorney General had no legal defense to this matter. And therefore, the statement, the unfortunate statement that was issued, and the haste of the Attorney General to slip something in on Friday, I leave it up to you as to whether you'd like to make a comment on what I've just represented or not.
Well, I know that your contention there is maybe even more informed than me as a as a political figure. I don't want to comment on that, but I want to say that the application, and this is from the perspective of the applicant, there is she felt that there is a mischief afoot. And if this interpretation is not properly addressed, or had the matter not been brought to court, and what was being done on the ground was enough to cause some concerns, because you're not only having new people coming who don't know an address. You had a situation where persons could not even give directions to the address that they claim that they reside at. So at situations where you had I think there is one example that she was given where the official is saying, all right, you don't have to give us directions. We know where it is, all right. And so you know, and so I mean, as much as we can speak civil about this matter, it is a very, very serious concern, because you have, I know that some of the examples that were preferred to was coming from, when we enlarged the matter in court, was that what if the person had taken the persons? I mean, that's a different case. What if you didn't see a house, or you saw, you know, makeshift house with zinc or plastic or what it case may be? That's where the person lives. That's quite all right, because that's where the person can be contacted. And so I don't believe it will be a basis for us to not register the person. But this is not the case. There has not even been a situation where the applicant is saying that the person applying or registering was taking the official. They didn't take the officials. The officials just went there, according with the act, with the various party representatives, to affirm that there exists that address. Now, interestingly, the attorney for GCOM mentioned that in itself doesn't even make sense. That because this act says that you have to visit, if you, as the GCOM official and the party scrutineer, you are aware way in advance that this address exists, why are you going? For what purpose are you
If
going?
you go
You
and you
all right?
find no house, what do you do?
Exactly.
As in
So therefore,
the case brought to the public attention um, about a single building on the East Coast at which more than 110 new registrants claim to reside. How do you fit 110 people into that building that was photographed and published? I mean, what is the motive? Why would you go to the extent of stretching it? And in Lethem too, we had more than 100 people registered at an empty lot, a lot with no house. If you're going
but,
to defend that, you have ulterior motives.
well, I mean, one could raise the argument that that is by choice, that the person lives on an empty lot and enjoys the fresh breeze in its fullness. And
And
so, and if the person decides, I don't want to have a house, I mean,
the
we are
shimmering
not
light of the moon.
we
But
we are not nitpicking the argument here as to what the condition under which a person is living. But the question is, are we going to go to that stage where we understand that the interpretation means that the person being the subject must be an address where that person can be contacted? Meaning, can I send a letter to that person? Can I visit that person there and find them there? All right. And so it takes on a practical connotation that you just can't give an address. I want to also say that, let's say, and we're not even thinking of this as far, let's say you who reside at an address, some stranger decides that they are going to use your address. There is a police story, and the police now comes at your address. So all the persons in your house is now arrested. They are
persons
now
of
arrested.
interest.
You understand me?
Yeah.
The use of an address is quite important. The way in which the interpretation or the application of GCOM seems to suggest that it now carries no value. The applicant disagrees on that.
I have a question. I have a question for you, totally removed from the case, perhaps. The opposition, the joint opposition, the labor movement, some members of civil society, citizens in general have been calling for a clean voters list and biometrics. The call for biometrics is in a limited form, as I understand it. Digital capturing of fingerprints, palm prints, and so on. Some have suggested retina scans and so on, but nonetheless limited. So if you digitally capture fingerprints at the registration process,
Mhm.
that has to be tied to a person and an address.
Mhm.
Now you're going to use um, that aspect of biometrics as a means of identifying the voter at the place of poll. So having captured it here at the registration office, the person now presents him or herself at the place of poll, puts down those fingerprints and so on. Would the information coming up not be the person's name, national identification number, gender, age, date of birth, and address?
Address?
And
Yes.
would that not aid in the process of tying the voter to the address where residency is required, and we have established that is required at the level of regional elections, and that it may be necessary at the level at one aspect of in one aspect of the national elections? Given that, do you see biometrics as assisting in this whole business of connecting people to geographic spaces and at the same time eliminating or reducing in large measure duplicate voting and impersonation of voters?
I would say that the issue of biometrics has been, rightly so, a call by, I would say, all the parties. Government at some stage when they were in opposition were calling for biometrics, and now opposition, they are very strong on this biometrics things call. Now this is I think has been a progressive way in which we have seen a number of countries around the world have gone to have biometrics voting. I think one of the most recent examples that I saw being used is the country of Ghana, which just completed its elections and
Yeah.
which in a very short time were able to use biometrics. So the issue of biometrics, I think it just goes to underpin that call goes to underpin, I think, that there must be, again, this issue of integrity of the elections. And I mean, no one wants to go back. I mean, we talk about discomfort. We talk about contentions being coming after the aftermath of elections, and we talk about a number of other things which continues to be the defining factor of the elections in Guyana. And therefore, I think the call is it's a valid one because it again it allows us as a people and as a country to be comforted with the results. And I think that basically is where the parties are heading. Um, I didn't see, in all fairness to GCOM, I didn't see that GCOM outrightly said it's not something to be considered. I think their argument, based on what I've been reading, um, is an issue of their time. They're saying that it might not be enough time to do that.
Well,
Of
it took
course, there
four
is.
years. It took 4 years to discover it would take time.
Well, Ghana showed that they were able to do that in weeks.
Yeah,
So
but
register in weeks. So
GCOM took more than 4 years to discover that this thing will take time, which is
yes.
quite
So
interesting. Dr. Todd, your closing remarks regarding the matter before the court, which will be ruled upon on Friday, 28th March 2025.
all I wish to say is that elections remain to be a very pivotal part of our democracy. Selection of our leaders and our representatives. Now, this amendment has caused some form of discomfort and has raised a number of issues in relation to the persons operating on the ground. How do they treat new registrants? New registrants, we're having being registered at different parts of our country. Now, the case is important because it tells us how GCOM must treat a permanent record. Permanent record meaning the NRR. So this matter is not about, even though it's an off spin to an elections, it is not about general elections. It's about ensuring that accurate information goes into the NRR, in which at a later stage, when there is a need for an extraction to get an electoral roll, then whatever is extracted from the NRR would be accurate information. Constitutionally, and we will say more than that, lawfully, it is within the mandate of GCOM to ensure that the information being inputted into the NRR is accurate. And as I said, that NRR, that permanent information is used for a number of other things outside of elections. All right. And so other agencies in our country can, of course, feed from that information. And so you don't want to be callous with that registration in putting unverified information into the NRR, so that other agency, if they were to use or apply to get information, they themselves will be affected because the information will not be accurate. What in essence one wants to promulgate is clearly, if a person lives at a particular address, say you live at a particular address, let's have honesty in the application. If a person resides overseas and is now coming back, they must not have to lie about an address so to put them in a particular area, because that will stop you from voting in the general elections, as you see this progressed, and unable to allow you to vote, even if you are what is considered as a non-resident. So a non-resident can vote. All right. Now, I would say that the definition, which we had used for a number of years, is that we were only talking about students overseas, and we were talking about persons who were working with the embassy or some organization attached to the government of Guyana. We no longer have to think about that, because I believe the case is settled, the case of Ram is settled, the amendment has settled that portion of it, so that you can be a non-resident and still return and vote. You cannot be disenfranchised from voting. The only issue which now comes is the various forms or types of elections in which you can be a part of. And I believe that needs to be clarified in relation to this amendment. And so the issue of the interpretation becomes very valid for our progression towards registration in Guyana.
Thank you very much, Dr. Dexter Todd, attorney at law, for joining me here on Nation Watch today and bringing clarity to the issue at hand. I want to close with Article 9 of the Constitution, which Dr. Todd had alluded to as well, and which I and many with whom I associate feel very strongly about. Article 9 says that sovereignty belongs to the people, who exercise it through their elected representatives and the democratic organs established by or under this Constitution. The people must be heard. The people in this case are represented by the applicant in this case and by the attorney at law, who graciously joined us on the program today to bring clarity to the issue. And we trust that the people will be heard. And well, the people have been heard, and we trust that the people's request will prevail, and we will abide by the final outcome of this matter. And note I say the final outcome of the matter. Dr. Todd, thank you again for joining me, and I look forward to talking with you again after the ruling is made so that we can look back at it and bring more information to the people of this country. Thank you very much.
Thank
And
you
to
for
our
having
viewers,
me.
yes, most welcome. And to our viewers, thank you very much for joining and staying with us throughout the duration of the program. It's been a little long, this episode has been a little bit long, but thank you very much for your patience, and we do look forward to seeing you again next Sunday by God's grace. Until then, be safe.